Hello and welcome to Reef TV. I'm Greg Patterson, Membership Services Director at Reef. In this episode of Reef TV, we look at the vexed problem of managing the employee who is not performing to the level you expect from them. Perhaps their sales figures simply don't cut it, or their constant lack of attention to detail is driving you crazy and causing embarrassment to the agency. Joining me today to look at this subject is Matthew Robinson, partner with law firm FCB Workplace Law. Matthew is an accredited specialist in employment and industrial law with the Law Society of New South Wales. FCB Workplace Law regularly advises and acts for real estate agencies in employment litigation, particularly post-employment. Thanks for joining me, Matthew, to discuss and examine a subject that many managers find frustrating or irritating, or both, as well as legally dangerous. So can I start by asking you, if an employer ignores performance or conduct issues, what are the business risks?
Thanks, Craig. Well, I think the primary risk is a financial burden upon the organisation. You've got a poor performer within your business who is not going to be contributing the way it should be. So you have a situation where an organisation is not going to be reaching its financial targets. That's the business and financial aspect of it. You also have the difficulty where this person will get to the point where an organisation would like to move upon them, to exit them from the organisation. Now, if you haven't managed the poor performance previously, raised it and identified it, provided warnings, you'd end up bouncing into some difficulties in trying to exit that person in a lawful manner. They're likely to bring some form of unfair dismissal claim or some other form of legal claim against the organisation because you haven't provided the appropriate ways for them to be exited.
Well, Matthew, from your vast experience, can you provide a brief overview of best practice procedures in managing staff performance or conduct issues?
Yeah, certainly, Greg. I think the key aspect on it is to lay the platforms for an employee. Firstly, what is the job that they've been asked to do? If you don't understand what the job they're asked to do, then it's a bit hard for you to then criticise them for not performing that job. That's number one. So a job description, a clear outline of statements of what they're responsible for. The second aspect you need to provide is some sort of performance targets. What are they supposed to meet? What are your expectations as an organisation on that particular employee? If you haven't done that, then once again, you don't have an ability to measure that employee as to whether they're doing their job properly or not. If you haven't done that, your performance management process is going to fall apart from the very beginning. The next aspect is to be able to then have appropriate evidence, like metrics or whether that person is meeting these things. So often it comes in two ways. One is objective evidence of the person not meeting sales targets or not having met appropriate number of people. The other one is subjective elements, whether they are being polite to somebody, whether they are contributing appropriately as part of an office culture. So they're the subjective components. You need to be able to measure those. If you can't measure those, then once again, you can't identify the fact the person's not performing properly. Assuming all those have been obtained, you then have a scenario where you need to address and raise these issues with the employee. You'd initially start off by doing it by way of a counselling session or a discussion with the employee in a non-confrontational way, reminding them of what they're supposed to do, what targets they're supposed to meet. You'd also want to provide them with assistance. For example, if they're having difficulties meeting targets for a particular reason, they can't access things in the computer system or otherwise that they're having difficulties with their phone or their car, you should see if you can try to resolve those. Now, assuming all those have occurred, you then need to advance the process. You escalate into a disciplinary process. Now, as part of that, you should be providing an employee with a letter or some sort of correspondence or outlining the areas in which you believe that they are not properly performing. They should be provided with this document or notification in advance. Sit down and have a discussion with them and then hear what they have to say in terms of why they do not believe that they're meeting these key requirements. So ideally, you might want to bring a support person into that interview, and the employee should understand clearly that this is in fact a disciplinary meeting. So once you've had this discussion, you've heard what they have to say, there might be legitimate reasons why they're not properly performing, and there might not be. So coming out of that meeting, you can then elect to either provide the person with, say, a first warning or a warning of some sort to indicate that unless that they consistently meet particular targets, their employment is in jeopardy. So you need to provide a warning letter of some sort if you'd like to escalate it. The warning letter needs to clearly indicate the areas in which the person is not properly performing and indicate areas in which they need to adjust and improve upon, a time frame in which that they are to do these things, and also clearly indicate if they're not meeting these particular targets, their employment is in jeopardy or may be terminated. If it doesn't contain those last aspects, then it's really just simply a letter of guidance as opposed to a warning letter. Now, assuming you've gone through the warning process, the employee receives it, you then have to once again measure their performance versus the targets that you have said that they should be met. And so if you're not measuring it, you're not properly keeping an understanding of whether they're doing it or not, then you're once again not being able to justify a termination process. Now, assuming that person has once again not performed their targets, then you get to the point of repeating the warning process, but this time in a termination-based arrangement. You then be providing the employee with a notification that they're required to turn up for a meeting. Usually it should be put in writing as evidence of this having occurred. We provide them an opportunity to come into this meeting and then provide a meaningful response. You then listen to what they have to say, and then as an employee, you make a decision as to whether, having regard to their reasoning and basis for the objections versus what you've measured and what you've previously warned them in relation to, as to whether or not their employment should continue. So you make that decision as to whether or not they have not met these targets. They haven't met the targets. You then discuss the employee, well, what do you think we should be doing with you? What do you think in terms of disciplinary action? Should you be subject to a demotion? Should you be transferred to a different work type? Or should the ultimate sanction on the employee, termination of their employment, be the ultimate remedy? So if you've gone through these processes and you've got to this particular point, you make a decision to terminate the person's employment. Now, you have to have regard to the severity of the issues in dispute. For example, an employee putting in 2 staples in a piece of paper is hardly a basis to terminate someone's employment. You can give someone a warning over it, and you then terminate them for a couple of weeks later for doing the same thing. It's not going to stack up. So the more serious the contraventions of their obligations, the quicker you can move upon it. Now, having said that, this is a warning process for poor performance or for poor behaviours. There are types of conducts which justify summary dismissal, so fighting, theft, the sorts of things that you would consider to be serious misconduct. You don't have to go through this performance management process. You can go straight towards a dismissal process. But that's the ideal process you'd embark upon.
Yeah, that's great, Matthew. That leads me to the next question, actually. In terms of performance management, we often hear members quote the phrase, 3 strikes and you're out. In other words, an employee must be given several chances to improve their performance or behaviour before they can be sacked. Is this expression an urban myth, or does it have some practical application?
Yeah, it's a bit of an urban myth. I've touched on this briefly in part of my previous answer, Greg. But for issues of summary dismissal, so serious misconduct or willful neglect, you move straight towards a termination. The suggestion of providing a warning is not going to necessarily fly. You wouldn't give someone a warning for stealing your money from your trust account. So it's simply instant dismissal. So we go back to the previous performance management processes. I talked previously about someone putting multiple staples in a document. You would need to have multiple amounts of warnings, maybe even half a dozen to a dozen warnings in order for you to justify, even if then, moving on that person. So where there are particular performance problems, you have to use common sense to ascertain whether they are serious performance problems or relatively trivial ones. Where they're relatively trivial, you may need multiple warnings and multiple opportunities for someone to respond. So that may be 4 warnings perhaps. But where someone is consistently not meeting performance targets, you've counseled them in the past, not engage in a warning, it might be that 1 warning is sufficient if they are simply performing at a really quite poor level. If they're borderline, then you might have to move towards multiple warnings, say 2 warnings. But the suggestion that a one-size-fits-all 3 warnings and you're out, that doesn't apply.
A lot of members, Matthew, express the view that the process of performance management is either too difficult or too confrontational, and that making the employee's position redundant might be less painful. What's your response to this observation?
Well, I've got a number of difficulties with that. As a business person, you are meant to be guiding your staff and how you run your business. Where you're not setting appropriate standards of how employees should be performing and indicating to the rest of your workforce how performance is meant to be set, you're really creating a culture within your organisation that poor performance is not something that is necessarily going to be tackled. All right, so that's probably point number one. The second point is that in most instances that I've dealt with where people use redundancy as an excuse to performance manage, it's in a critical role, like a sales role or a secretary or someone in a part of the finance team. The employer needs them as part of an intrinsic part of operating their business. Where this person is suddenly made redundant and then someone is rehired in that position fairly shortly thereafter, you're creating a sham redundancy arrangement. You firstly expose your organisation to tax consequences. So as part of a redundancy arrangement, there are tax beneficial arrangements for the employee's departure package. And so where you have done that, you're exposing yourself to actually undermining how much tax should have been paid for the termination pay. The ATO may come knocking on your door, not tomorrow, but maybe in 2 or 3 years' time, or even via an audit of that particular employee. And suddenly you have to justify why a person's position was made redundant on a Friday, but you rehired somebody in the same role doing the same thing on the Tuesday. So they've got exposure for that. The other aspect of it is in relation to claims by the ex-employee for their termination. It's often the case it's a critical role. The person's removed on the Friday afternoon, given their cardboard box, moved on, I'm sorry, you're made redundant. And there's an ad in the paper, there's a job on Seek or something or other, which the employee sees. Now, an employee's got 21 days from the date of termination to bring an unfair dismissal claim. So that means that an employer who wants to pull the redundancy trick has to effectively wait around about 21 days before they take steps to rehire someone. Not too many organisations want to be answering their own phone for 21 days because the receptionist has been removed. So what it does is as soon as there's a rehire, the employee sees it or their ex-workmates tell them that someone's been rehired and suddenly there's an unfair dismissal claim being brought in and it's a sham redundancy. And it would, most instances, it's a laid-out misère for the employee to show, this is the job that I had, this is a job that they've advertised, it's exactly the same. And then the employer is left trying to defend themselves in a pretty defenceless way. So look, I would suggest that if you want to tackle performance problems, redundancy is not necessarily the best answer. You as a business leader need to lead, and part of being a leader is actually setting standards and making sure employees adhere to those standards.
Well, Matthew, I think it's become fairly common knowledge that an employee who is of the view that their employment has been terminated unfairly has the right to challenge the employer's decision. Can you explain what avenues of redress are available to an employee in such circumstances and the possible consequences if there's a finding against the employer?
Yep, certainly agree. Well, there's a number of ways in which employers can challenge their departure from an employer. The most obvious one is an unfair dismissal claim. There are some limitations in which who can bring in claims for unfair dismissal. I'm not going to touch upon that right now, but they can certainly bring an unfair dismissal claim in the Fair Work Commission. They can also bring claims if they've been had employment terminated unlawfully. For example, they've been on short-term sick leave. There's other areas such as called general protections disputes. So where they've raised complaint in relation to their employment or their working conditions and then suddenly they've been removed, they can bring a claim for called general protections in the Fair Work Commission and ultimately through the court system. There's also other ways in which they can challenge the termination on discriminatory reasons, say age, sex, race, those sorts of things, the common understandings of discrimination. The most common aspect is unfair dismissal. Now, the risks associated with those are firstly financial risks. The employer will then have to fork out some money to try to defend the case. In most instances, the matters settle at conciliation conference, in which case the employer is paying some goodbye money or go-away money to the employee to depart. They are difficult, stressful processes to do. If the matter can't settle, for example, you face a recalcitrant employee who simply wants their pound of flesh, yet the employer is then being dragged through a process which they ultimately can't control and can require the Fair Work Commission to reevaluate the termination process both substantively and procedurally as to whether it was fair. Did the employee receive a fair go all round? Now, decisions from the Fair Work Commission are public decisions. There's often journalists who like to eavesdrop and listen to what's going on, pick up the written decisions. And so with that comes not only the financial consequences of potentially paying damages, but also reputational issues as well. So your brand can be on the paper, the local paper, or perhaps one more of a particular local website showing what you've done or haven't done. So it's often the case that it's cannon fodder for journalists to pick these things up. Now, the remedies that are available for an unfair dismissal claim range from up to 26 weeks' pay if the employee's been heinously removed. Alternatively, the employer can be required to re-employ that person. You must hire that person back either in the same position or an alternative position. Now, in addition, they can also be required to pay back pay. That is, from the date in which the person was terminated up until the date in which they were reinstated, there's an obligation to pay that person back pay. Now, given the speed in which these matters are addressed by the court, it may take 8 months, 9 months before the matter is finally determined. So you could have a scenario whilst the maximum compensation payable for an unfair dismissal is 6 months, you may have an order to re-employ the person and back pay them 8 months or 9 months pay. Now that's disastrous. So where an employee is reinstated back to their role, it sends a clear message to staff that the employer, the manager, doesn't know what they're doing. They're not in control of their organisation. So the risk of a reinstatement, re-employment order it has substantial cultural impacts as well. So there's a number of risks. So summarising them again, financial risks, cultural risks, and reputational risks. They're the areas.
Thanks, Matthew, for that excellent overview on the need for, but the dangers associated with managing an employee's unsatisfactory performance or conduct. Thanks for watching this episode of Reef TV. Don't miss our other episodes that deal with a range of employment topics to help you stay on top of the latest workplace relations information and news. I'm Greg Patterson. See you next time.